case briefs, and so much more. LSData's got what you're looking for.
The Supreme Court of the United States was embroiled in a tariff classification dispute in 2001 during the United States versus Mead Corp case. The underlying contention? The categorization of Mead Corp's imported day planners by customs for the purpose of tariff imposition. At the genesis of this legal battle was a seemingly innocuous decision by customs to classify the imported day planners as diaries, thereby subjecting them to a higher tariff rate under the Harmonized Tariff Schedule of the United States, HTSUS. The reclassification was a clear shift from their initial categorization as other. The new label did not sit well with Mead Corp, prompting them to contest this move, only to have their protest rebuffed. Charging on, the corporation took the battle to court, disputing the deference of such classification rulings. The central issue revolved around the interpretation of the term diaries and whether ring-bound day planners could be indeed classified as such under the regulations. Justice Souter, writing for the majority, delivered an intriguing resolution. While deeming customs classification undeserving of the typical Chevron deference, he did allow for a modicum of respect based on the persuasiveness of the ruling under the lesser-known Skidmore deference. This form of deference holds that the weight given to an agency's interpretation of a statute depends on its thoroughness, logic, consistency, and expertise. Asserting customs authority to establish the final classification and impose tariffs on merchandise under HTSUS, the ruling validated the binding nature of such rulings on all customs personnel, barring any changes or revocations. This landmark decision signaled that while Chevron deference might hold no sway over customs classification rulings, there was room for some level of deference under Skidmore. Consequently, the case was sent back with instructions for the Federal Circuit Court of Appeals, or the CIT, to perform further proceedings employing the Skidmore assessment. The result was a vacated judgment, setting the stage for another round in the tariff classification saga, albeit with a more nuanced view on deference.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.